is it depends on what kind of debtor we're dealing with. If we're dealing with a business debtor, generally the only debt that isn't discharged is a non-dischargeable tax debt. Other debts are discharged, and as a matter of fact, in a business case, the debtor gets the discharge upon plan confirmation. On the other hand, if we're dealing with a Chapter 11 for an individual or a married couple, things are quite different. First, the debtor doesn't get a discharge upon plan confirmation, but upon plan completion. And that could be 5 years after the plan has been confirmed. As far as debts that are non-dischargeable in the Chapter 11, unlike Chapter 13, which has a shorter list, in Chapter 11 for individuals and married couples, the list of non-dischargeable debts is the same. And they include, well, rather than going through the entire list, I'll give you a list of the kinds of debts that frequently come up. There are going to be some others. Most tax debts, there are some tax debts that are dischargeable, but those that are not dischargeable in Chapter 7 are also not dischargeable in a Chapter 11. Student loans, obligations to pay child support or alimony, fines or penalties imposed by a judge to punish the debtor for having done something wrong, debts that are incurred through fraud, debts that are the result of a breach of a fiduciary duty, debts that are the result of doing willful and malicious harm to a person or property, homeowners' dues that come due prior to the day the debtor files the bankruptcy papers. There are others, but those are the ones that come up most frequently. And there is one other that is a little bit tricky, because when you hear obligations to pay child support or alimony, this one that I'm about to describe you, I think, is just sort of a subset. And it isn't. This additional debt is a debt to a spouse or a former spouse that is not child support or alimony, that was incurred as part of a separation agreement or a divorce decree, or was assigned to that debtor as part of a separation agreement or divorce decree. And a simple example, I think, can illustrate what I'm getting at here. Suppose the couple goes to the divorce court and the divorce judge says, okay, I'm assigning debts. You get this debt, you get that debt, you get this debt, you get that debt. So let's say it's American Express, Bank of America, Chase, Citibank. So one of the debtors goes into a Chapter 11 and lists these debts. Well, with respect to those four creditors, American Express, Bank of America, Chase, and Citibank, the debt can be discharged. But suppose that happens. Well, Bank of America takes a look at its records and sees, well, I can't go after the debtor that just went through the bankruptcy, but there's somebody else on this debt. The ex-spouse, I'm going to go after the ex-spouse. And so they go after the ex-spouse, and that ex says, hey, wait a minute, you can't go after me. That debt was assigned to my ex-spouse in the bankruptcy. Bank of America is going to say, you can't shuffle papers around and prejudice our rights and pay up. So the ex-spouse then will go back to the divorce judge and say, Your Honor, you ordered my ex-spouse to pay this debt. That person isn't paying the debt. Order my ex-spouse to pay me so I can pay the debt, and the divorce judge will apply. So it's in that sense that you have a debt to a spouse or a former spouse that was assigned in a divorce decree or separation agreement, and that's not dischargeable either.